In Woolley versus the Ministry of Justice, the claimant brought a personal injury claim against the Ministry of Justice following an assault he suffered while a remand prisoner. At a CCMC, Her Honour Judge Baucher significantly reduced the claimant's cost budget. The claimant argued that the judge had erred in law by refusing to consider the defendant's agreed costs budget when assessing proportionality of his own. He also submitted that the approved budget left him with much lower funding than the defendant, failing to keep the parties on an equal footing. The Ministry of Justice contended that comparisons between budgets were of limited relevance. It was for the judge to assess proportionality of the claimant's budget, which she had done. The High Court allowed the claimant's appeal, finding that the judge had disregarded a relevant consideration in refusing to hear submissions based on the defendant's budget. Quote, "The judge thereby disregarded a relevant consideration, as the claimant asserts in the first ground of appeal. The defendant's budget was not intrinsically irrelevant. Some comparison between budgets may be informative, as was said in various claimants versus Scott Fowler solicitors. The defendant's budget did not become irrelevant merely because it was agreed, or because the judge may have disagreed with the reasonableness of the amounts in it. Mr. Gritters was entitled to make submissions about it for what they were worth and was prevented from doing so." For a full summary of this case, visit tmclegal.co.uk.